Welcome back to Piercing the Corporate Veil, Lessons from the Docket. I'm Professor Seth C. Oranburg. In our first episode, we laid the groundwork by exploring the purpose of limited liability and the corporate veil through some foundational cases like Wallace v. Carlton and Becker v. Interstate Properties. Today, in episode 2, we build on that foundation by examining the specific tests and triggers that courts use to decide when to pierce the veil. We'll see how factors like undercapitalization, commingling of assets, and the failure to observe formalities come into play. We'll draw directly from real facts of appellate cases to show why some corporate structures hold up while others don't. These tests will recur in future episodes, such as Episode 3's application to LLCs, Episode 4 and 5's advanced variations like reverse and horizontal piercing, and Episode 6, regulatory contexts. Let's start with a case that perfectly illustrates the alter ego test and the importance of maintaining corporate separateness. C Land Services v. PepperSource, decided by the Seventh Circuit in 1993. In this dispute, C Land Services, a shipping company, had contracted with PepperSource to transport Jamaican sweet peppers. Everything seemed routine at first. PepperSource was a corporation engaged in importing and distributing food products. But when PepperSource failed to pay for the shipping services, Sealand sued and obtained a default judgment against the company. As Sealand tried to collect on that judgment, they discovered that PepperSource had been dissolved and had no assets left. This left Sealand holding an unenforceable judgment. Sealand was unable to recover what they were owed. Digging deeper, Sealand uncovered that Gerald Marchese was the sole owner of PepperSource, and he controlled several other corporations too. Further facts showed Marchese had treated PepperSource's bank account as his personal funds. He used corporate money to pay for his personal expenses and the expenses of his other businesses. Multiple accountants testified about Marchese's practices. He would regularly withdraw funds from PepperSource in ways that left the company insolvent, apparently to avoid paying creditors like Sealand. This wasn't some random mismanagement. The pattern suggested a deliberate effort to strip assets from the corporation after debts had accrued but before creditors could collect. Marchese's other corporations were similarly structured, with overlapping operations but no real separation in how funds were handled. The district court examined these facts and found that Sealand had proven both prongs of the veil-piercing test under Illinois law, and, crucially, the Seventh Circuit agreed. They affirmed the decision to hold Marchese personally liable. This case shows how commingling assets, mixing personal and corporate funds, can destroy the separation that limited liability depends on. When owners like Marchese use corporate money for personal purposes without proper accounting, courts see it as evidence that the corporation isn't truly separate. This sort of echoes the undercapitalization we saw in Wallace v. Carlton in Episode 1, but here we have additional factors. Sealand demonstrates how deliberate asset stripping can trigger veil piercing. In Wallace, the structure limited recovery for accident victims. Here, it left business creditors empty-handed, not just limited. In Wallace, there was a respect for formalities and separate bank accounts and a minimum amount of insurance. Here, we had none of those things. This theme underscores a key point. Courts look for patterns where the corporate form is used not for legitimate business, but to evade responsibility. And these are patterns we'll revisit in Episode 4 and 5's Advanced Piercing Doctrine. Let's turn to another case that adds a layer to our understanding of veil-piercing tests, Wallace v. Wood, from the Delaware Court of Chancery in 1999. This dispute centered on CENTCOM Cable Income Partners II. It was a limited partnership formed in 1987 for the purpose of acquiring and operating cable television systems. The partnership's offering, meaning their attempt to raise funds, sought to sell 250,000 units, like shares of stock, to investors, but they weren't able to close the sale. Sales fell short, and they only sold 90,915 units, leaving the partnership with significantly less capital than it had planned for its acquisition goals. The partnership agreement included a strict limitation on borrowing. Debt for acquisitions could never exceed 20% of the gross proceeds from unit sales. That was baked right into the partnership agreement. The constraint, however, created a major hurdle for the partnership's operations. And so, to get around it, the general partner got a little clever. Related entities allegedly created additional entities that were primarily owned and funded by the partnership itself. These entities would incur the debt for the acquisitions, effectively bypassing the agreement's restrictions. These facts revealed tight interconnections among the parties. 3 of the 4 officers were directors of the general partner corporation, and the 4th served as its general counsel, its lawyer, and secretary. The general partner's stock was owned by a parent company, which was in turn owned by another parent controlled by the same officers. Through this structure, the defendants generated substantial fees for themselves from the acquisitions, while the limited partners suffered losses of 12.1 to 17.6% on their investments. The plaintiffs claimed this arrangement breached fiduciary duties and warranted piercing the veil to hold the officers, affiliates, and parents liable. The court analyzed whether the partnership and its controlling entities had maintained true separateness, or if the structure was merely a facade for self-dealing. The case highlights the instrumentality test, where courts ask, does the corporation serve as a mere tool for owners' personal objectives? In Wallace v. Wood, the overlapping roles and fee-generating schemes suggested the entities weren't operating independently, but as an instrumentality for the officers' benefits. It's a reminder of how failure to observe formalities, like proper governance and arm's-length dealings, can erode corporate separation, a theme that echoes forward. In this particular case, it was a violation of the partnership agreement, maybe not in words, but in deed, and the court equitably pierced in that instance. Building on Becker v. Interstate Properties, where the developer's use of undercapitalized subcontractors left a worker uncompensated, Wallace shows similar risks in partnership structures. In Becker, the facts involved a construction accident with inadequate insurance. Here, there was financial manipulation in a limited partnership. This repetition across cases helps us start to see a pattern. When control is used to shift losses onto others, courts might step in to restore equity, fairness. These examples lead us to the core test for veil piercing. While standards vary by jurisdiction, most courts use some variation of a 2-part framework. The first part is the unity of interest, also known as the alter ego test. This first part looks at whether the corporation and its owners are truly separate, or if they become so intertwined that the corporation is just an extension of the individuals. Factors in this first prong of the test include common ownership and control, like we saw in Sealand, where Marchese dominated multiple entities and was the sole owner. Courts also examine if funds are commingled, mixing personal and business money without clear records. In Sealand, Marchese used corporate funds for personal expenses, thus blurring those lines completely. Another factor is undercapitalization, meaning the company starts with too little money to cover expected risks. We sort of saw this in Walkowski v. Carlton, where each taxi corporation had only minimal insurance. This was inadequate for the known dangers of urban driving, but it met with statutory requirements, and so we have a slightly different result in that case, but it was close to the line. Repetition of this factor across cases, like Walkowski and Becker, emphasize its importance. If a business is set up to fail financially from the start, courts should and do question its legitimacy. Failure to follow corporate formalities is another red flag. So, not holding required meetings, not keeping minutes, or ignoring bylaws or the partnership agreement is another basis for piercing. In Wallace v. Wood, the overlapping roles of officers and directors who made machinations to do end runs around the partnership agreement suggested formalities were being overlooked to facilitate self-dealing. The second part of the test requires some element of injustice or wrongdoing. Now, this isn't always outright fraud. It can be using the corporate form to evade obligations or leave victims without remedy. Fraud is a good reason to pierce, but it's certainly not the only one. In Sealand, the injustice was leaving creditors with an unenforceable judgment after deliberate asset removal. In tort cases like Becker, it's about uncompensated injuries from foreseeable risks. Courts also distinguish between contract and tort contexts. Contract creditors voluntarily deal with the company and can theoretically protect themselves through negotiation. Tort victims, like the injured worker in Becker or the pedestrian in Walkowski, have no such choice. Torts are involuntary, so courts tend to be more sympathetic, a distinction that could prove crucial when we talk about involuntary victim analysis in Episode 6. So repetition of these themes, namely undercapitalization in Walkowski, commingling in Sealand, and control issues in Wallace, shows they're not isolated. These are patterns that we can see and look out for. We'll see these factors adapted for LLCs in our next episode. But as we wrap up, remember that these tests are meant to ensure limited liability serves its purpose without becoming a tool for fraud. The key takeaways from today include the two-part veil-piercing test, which requires unity of interest, which is also sometimes known as the alter ego theory, and injustice, which can but doesn't necessarily include fraud. Key factors to show that we should pierce include commingling assets, undercapitalization or lack of insurance, and failure to follow formalities. Courts are more likely to pierce for tort victims than for contract creditors because contract creditors could protect themselves through negotiation, whereas tort creditors are involuntary. And these patterns will repeat as we study piercing the corporate veil. Thank you for joining me in this episode. I'm Professor Seth C. Oranburg, and I'll see you next time.